Uh, what, as in a further addendum, just talking and focusing on the law itself and the characteristic of the difference between South African law and the American system, is that the American constitutional framework, in some sense, only applies against the government itself. It doesn't work, you cannot vindicate your rights against other private citizens in a kind of personal capacity. Uh, this, I think, is fundamentally egregious on the level of trying to have a justice system that entrenches something like a law of general application in the fullest sense of being able to do something which is quite sophisticated in terms of solving the liberal intolerance paradox, which is essentially America is all geared towards that the democracy is on call for delivering on that issue or on giving an answer to that issue, or it's part of the messy experimentation, as it were. But the South African constitution instead does the much harder task of actually imposing obligations against other private citizens based on constitutional rights. But not all, and essentially how it does this is that it has a general limitations clause on how infringements of constitutional rights can be justified. And it also has the practice of equality and provisions that make clear what the practice of equality entails. There's no right to equality, there's a right to equal protection and benefit under the law, but there is no right to equality in a society, but there is a right to equal protection and benefit under the law. In America, you only have a right to equal protection of the law. You don't have the right to equal protection and benefit. And this is a pure consequence of the fact that America does not have the rule of law, so it can't guarantee to people that they have equal benefit of the law. They can only have equal protection, and that protection is something that is prone to being repromulgated or repealed and replaced, or sort of that a new thing will come along, a new experimental law will be made, and it will be duly applied according to due process, evenly across the board. But in substance, the benefit that it provides there's no rigor, there's no substantive pushback that the individual can do other than through the democratic facility in the society. The only way to change the law is to appeal to your fellow citizenry and electorate, essentially, in changing the nature of your democratic representatives. So you have to appeal directly to your neighbors, somewhat generally speaking. You cannot extract justice for the individual through the judiciary or from the state. The democracy outvotes you. And you have to put up with that in the American system. And that is, I would argue, the quintessential nature of what social injustice truly is the rule of man, where the individual does not have equal access to justice against the majoritarian democracy. Now, even in my system, I still conceive that, and also make the concession, that you are still somewhat beholden to who the electorate decides to enrobe in governmental executive positions, choosing the legislative and executive functionaries to fulfill that constitutional role. And the democracy can hamper itself by making bad decisions, by being unvigilant, or that's not the proper word, is it? But is lacking the proper vigilance, or lacking the proper care and consideration in the selection of their chosen government. But the judiciary is a huge boon to the individual to at least diminish the power of the state to act in bad faith, predominantly through the General Limitations Clause, which has its sub-clauses that are lettered sub-clauses because they are intrinsic to the Limitations Clause. And the Limitations Clause cannot be read and cannot be utilized without full use and ascertainments of each of those sub-clauses that are lettered. That the lettered sub-clauses are intrinsic to the section. To Section 36 of the Bill of Rights, the General Limitations Clause. I mean, there's a special relationship between the provisions that outline the practice of equality and the provisions of the that are contained within the General Limitations Clause, and you kind of have to refer to them multiple times in some cases, back and forth in some sense. At least to properly understand what the position in the Constitution is on affirmative action. Because it is a sophisticated and nuanced matter. And if you're sloppy with the fundamental values of the Constitution and you're sloppy with utilizing the provisions in the General Limitations Clause, which the Constitutional Court has essentially, that is the crime that it has committed in betraying the Constitution and subverting it, not even slightly, but quite blatantly and reprehensibly so. A stain that will be a mark against the history of constitutional law in this country, a stain that must be lifted up and examined and magnified if we are to salvage. It is a wound that must be healed and recovered from so that the Constitution can come back to life. Right now it is a shell and a corpse for maggots and miscreants and evildoers that now sit and feast on the rotting flesh of what I consider to be the true beacon of the world and the only true example of the rule of law. And if South Africa could muster this feat, it would also leave the rest of the world in awe of exactly what is the solution to these problems that you see in America, because the American system is fundamentally, I would argue, it has reached its expiry date. It's fundamentally untenable in many ways, because in some sense the identity politics crowd are, in their tact, they are correct in terms of the American style of politics and the American style of government. Because in some sense, when they go to court, if you tried to take someone who was a social justice warrior in America, an identity politics proponent, if you tried to take them to court, at the end of the day, they would not hear a judge saying, what you're trying to do is irrational, it's unreasonable, it's morally repugnant, it's anti-constitutional. They would not hear a judge say that to an individual, because the Constitution does not bind the individual, it only binds the state and the government. In fact, they would hear, if the judge ruled against the social justice warrior, what they would hear the judge say is, the judge would say, because really there are no true judges in America, they are secretaries of the legislature. The judge would say, you are losing this case because you have not garnered the correct democratic support and to craft the law to compel me to rule in your favor. You are too democratically unpopular for me to rule against, for me to rule against your adversary or to rule in your favor. So I don't rule in your favor, not because you are unreasonable and wrong, but because you haven't won politically yet. That's what they hear the judge saying. And so justice is a fickle thing in the American structure. It's an experimental thing anyway. And the social justice warriors, they know this. They are, I would argue, somewhat the true sons and daughters of the American experimentation, of that so-called project of liberty. But it is liberty without accountability and responsibility and maturity. It does not properly contend with the liberal intolerance paradoxes, which is why you have to do these extrajudicial things every once in a while, like the McCarthyist Red Scare era and committees of anti-American, the Senate committee, or was I don't even know if it was a Senate or perhaps it was a congressional committee, or on anti-American activities, essentially having to create a court, an ideological court, out of the political legislative power in order to safeguard the structure. I mean, already then you could say that the system in America had overtly lost its integrity. Because in some sense, yes, people that represent the intolerance paradox, the liberal intolerance paradox, do need to be suppressed. They do need to be fought against. But the American system has no true ammunition to do anything about these things. And so it has to create these hideous things which in some sense invalidate the entire constitutional framework, like the McCarthyist Committee of Anti-American Activities. This is not, I mean, whatever happened to government shall make no law infringing on the freedom of speech and freedom of conscience, essentially, which is somewhat philosophically bound in with that constitutional right. It all falls away every once in a while when it's needed, because the system itself is unsound. The system itself is quite frankly, it's just a shell. And there have been some good byproducts of this shell, because in some sense the bad example is also a useful example for us to learn and mature and grow and develop from. So I don't want to be too harsh, but I must be critical, because this is an untenable form of justice, and it produces a misleading and disgusting form of the rule of man, which tries to claim ideological promises and pretty pictures. But in some sense, the American Constitution, in terms of its Bill of Rights, is quite useless. It is essentially political rhetoric. And if people don't consistently vote in terms of protecting that rhetoric, it is meaningless, because the democracy could even section out those Bill of Rights. Constitutional amendments could be passed that remove the Bill of Rights entirely. They are completely provisional at the behest of the democracy. This is not a system of justice. This is a system of fiddlers, and it's all up in the air. It's all, there is no true accountability. You can just rationalize and repromulgate, and the buck gets passed on. But the true thing is that to really have the rule of law, you need equal protection and benefit under the law. Justice must be blind in terms of its protection, but also in terms of its benefit. And that requires a much more rigorous kind of Bill of Rights. That requires a much broader legal, philosophical structure, one that has never existed in America, one that also doesn't exist in Britain as well. Although there are some enlightened elements of that legal system, in the sense of liberty, but that liberty is not properly countenanced against proper accountability and responsibility, which in some sense individuals will never be fully made responsible by something like secular law. But it's a useful structure to have a civics education around, because it will provide a template, because the city is a microcosm, or the city can be seen as a model of the microcosm in the psyche. This is how, when people grow up in a society and they learn about their surroundings and they learn about how functions work, then they can be told when they're very young, oh, this is what judges do when there are disagreements that people can't come to an agreement, then a judge arbitrates over them. Oh, tell me about, there are places, there are things within a society, and discovering and being knowledgeable about these things gives you, in some sense, not directly but indirectly, an impression about how the mind can be ordered and how the mind can be cultivated in order to be harmonious and conscientiously just in its sensibilities and proclivities and purposes and projects. And we have a sick society. We don't have, in South Africa, we don't have a sick society on paper, but what is on paper has been institutionally corrupted, or it has been papered over by institutional corruption that needs to be peeled away for us to recover the constitutional order that has been betrayed and subverted. A far superior system, the best in the world. And that is not, I don't say that out of a point of pride. I say that because I truly believe that is the case. And I say that also in an encouraging way, because I do think that South Africa can be an example for others to follow. But we have been horribly diverted by evil people, by immoral people, and we are now sick with this immorality, which also essentially is a structure of institutionalized corruption in the law itself. And so it's going to be very hard to uproot that immorality when simultaneously we suffer from a structure which has been bedeviled by wicked people that have made their house in something that did not belong to them, something that belonged to everyone, but that they brought in their ideology, they brought in their racialist quick fix solutions, they brought in their one-size-fits-all lowest common denominator sympathy, ideological grift and narrative, and they thought that they could justify it because it was fashionable at the time, because there were some academics that they could say, oh, well, that they're making a lot of noise and it's good to join the chorus of these devils. And so we sit with normalized fascism and an entrenched democratic illiteracy. A democratic illiteracy which I would argue belongs to America, which is their perennial problem. But it should not be South Africa's perennial problem. It has been imported to us by the wicked among us in our society, who started their wicked ways with their immoral and pathetic and stupid, feeble machinations around undermining the legacy of Mandela, because it helped them conceal their corruption. It helped them paper over and disguise their methodology of turning the state into a mafia organization, into a kind of syndicate of criminality that could go undetected because of the immorality that was being fostered into the system. And through the appointment of constitutional judges with this disgusting political ideology, they were able to recreate the American corruption in our law, which never knew it before, until it was imported here by these politically partisan constitutional judges and their wicked racialist ideology of so-called anti-racism and their reinterpretation of social justice to mean its opposite. And they have gaslighted a society, and at the same time they have destroyed democratic literacy. And this is a huge piece of the puzzle that we need to solve. Otherwise, there is only devastation ahead. Which, in the historical analysis, if that is to be the fate of South Africa, hopefully the moral lessons can still be salvaged from this. And perhaps a proper understanding of non-racialism will re-emerge after we realize that black people can be just as immoral as white people, that when we see black fascists take over institutions and corrupt and destroy things, like the University of Cape Town, that has essentially been devastated by this disgusting racialist ideology, which should never have been allowed to metastasize in a public institution that received public funds to promote their anti-constitutional rhetoric and toe their fascistic politics line and immorality and general corruption that helps disguise the state corruption. They have corrupted everything. And they have done so because of their hate. And they have justified their hate. By continually doubling down on their accusations, on their hysterical and escalating accusations, which continue to whitewash and to avoid their own dirty hands, because their policy has only led to devastation and failure, and they take no accountability of this. They use their own failure as the fuel for further escalations, their radical mischievousness. These are not only wicked people, they are mischievous. They are highly dishonest people. But I say that anti-constitutional propaganda will always have this quality to it. Anti-constitutional propaganda will be mischievous and wicked but essentially fundamentally dishonest. And we have become a society that has bent itself to the twisted contrivances of these fascistic demagogues in politics and their apologists, their high priests, their KKK grand wizards, purple-haired feminist lecturers. These are the fascists of our epoch. Yes, it has manifested in a slightly different way, but Hitler would have called these people useful idiots. I would call them proto-fascists. They are incapable of having any kind of healthy self-esteem. Their self-esteem is premised in pinning the tail on the donkey and pinning the accusation on their ideological adversary. They can only make progress by negative means, by negative inroads against their enemy, because they have no affirmation of positive values. Their values can only be extracted and excavated by excuse. They use in fact, they need their adversary. They end up with the same problem that the Nazis had, is that imagine if you actually fully exterminate all the Jews, then what do you do? Then how can you blame and divert any weakness that your society might still have? Well, then you have to have the Jewish conspiracy version 3. You know what they even said after they locked up all the Jews in the ghetto? Do you know what they said? They said, we have physically removed the Jews from our society, but we have not removed them from our psychology. They have still infiltrated the Aryan mentality. They have infiltrated Aryan consciousness, and the Jewish conspiracy still persists. It still works against us, and it will take generations to remove it. That's what they say. The boogeyman never dies. The ideological scapegoat never dies. And it's exactly the same with this lot of fascists. They complain about white supremacy. It's the same conspiracy theory as the Jewish conspiracy theory. These people are identical to fascists. They have the same mentality. They have the same psychology. They have the same culture. They have the same immorality, and they will boil us eventually, and they will take those who do not subscribe to their coercion. Eventually they will take them to the gulag or to the concentration camp. They have made these intentions very clear, and that is what the movement towards hate speech laws is: ideological enforcement, so that then their South African Human Rights Commission can become what it is in essence already, a Gestapo-esque kangaroo court, there to dole out the ideological interpretation of social justice, not the true constitutional definition of social justice, which we must remember before it was bastardized by these fascistic filth. Social justice is a term that comes from George Orwell, the guy who wrote Animal Farm. Because social justice is justice for the individual, not justice for the group relative to other groups. It's justice for the individual. Not justice for a category to leverage group guilt against another category, or to create blanket criteria that treats people like nominal representatives of some identity matrix. That imputes some fundamental ascription onto people based on pure ideological presumption that has never been properly substantiated. They get away with their hate because all of their claims go untested, and they shouldn't even have to be tested. They were never substantiated in the first place. They were never reasonable to begin with. They never made the claims. They never tried to substantiate the claims properly. And the judges let them fucking get away with it. It is the judges that have failed us and failed our constitution and failed our state. Primarily. They can argue that they bent to public pressure and they bent to the tide of history as they ideologically interpreted it, or perhaps I suspect that they more directly bent to the fact that they were politically planted there for their ideological sympathies. and their observance of this orthodoxy, even at the detriment of our supreme constitution, which they have murdered, and for which they should be sentenced and judged themselves. Perhaps not in this world, but perhaps in the next. Perhaps there is a circle of hell waiting to receive them. Those who do not repent of their wicked deeds. But it is very clear that these judges are part of a program that has essentially committed a crime against humanity, because what they have done to the South African Constitution in its betrayal of its fundamental value of non-racialism and its betrayal of the General Limitations Clause is a crime against humanity, for which all of those who have been involved should be impeached. They are unfit to serve. They are not judges. They are imposters. They are pretenders. It is that obvious. Now, I guess in some sense you can look at America and you can say, well, aren't all those judges really pretenders anyway? They're not really judges, they're secretaries. And that is the corruption that they have imported into the South African legal tradition, where it does not belong. We had something very different before it was destroyed. I only hope that it can still be recovered and resurrected. And perhaps this is better that it does, because if something can be reborn in full view, then it can perhaps serve as a greater example and a greater touchstone of understanding and pedagogy. That is all I can hope for, although perhaps it will be quite a dire scramble, and it will come down to the line, perhaps, who knows, how stark and how close to the brink we may come, and perhaps we will even fall. Either way, it does not change the principle of the matter. That is somewhat eternal. And South Africa on paper is still something that deserves to be emulated. And perhaps one can say that it was then just an accident of history that we suffer. Although the electorate must be culpable for this, but must be held culpable for this, but that there are certainly no lessons to be learned when only excuses are made. But when excuses are made for people that should be held responsible. But we could say that we could have had a more vigilant citizenry, which would have been more possible if we had had an education system that wasn't so devoid of a civics education, priming people with a kind of democratic literacy. That this deep subversion was only possible because the judges themselves did not have the temerity to take action against these wicked academics that were propounding anti-constitutional propaganda. They did not have the foresight and the vision to see the liberal intolerance paradox looming with public funds, perhaps because of the ideological pressure and the fact that fascists are so loud at complaining when they don't get their way. And it's interesting because perhaps we had such a good structure of law and a system that intrinsically held power accountable, that because our justice was so independent of politics, that it needed to be corrupted essentially for what would usually go on in politics and what would usually go on in the culture in a kind of codependency with the moral grandstanding that happens within politics. And the kind of trust, societies that are based on a kind of collective coherence that is based in an ideological narrative or picture of trust, which essentially has no integrity because it's never bootstrapped or grounded in the individual. It's only grounded in group categories and group categorizations and stereotypes and disgusting other forms of immoral, lazy thinking. That leads us into the mess that South Africa is in, but it's a beautiful example. As depraved as it is a beautiful anatomy of exactly why dysfunction is dysfunctional. The morality could never be clearer, and I certainly do indict the judges along with the electorate, along with the lack of a civics education. But how could there ever be a civics education if the judges can't even fucking get it right? And that's their only fucking role and job as, in some sense, supreme guardian of the Supreme Constitution, which they have shirked in not properly utilizing the General Limitations Clause. Finding a semantic loophole. Oh, it says the word democracy within the first paragraph of the Limitations Clause. Therefore, because the government is enrobed with the role of creating policy for affirmative action, we're going to invent something called a governmental prerogative from America. Because America has something called a governmental prerogative, so let's use the same term. Please. Governmental prerogatives have to do with purely executive functions like diplomacy, and even probably propaganda for war and acts for war can be constitutionally challenged, and the governmental prerogative would not hold. As it is even explicitly, and in some sense, how can essentially the only hate speech which the Constitution in some sense clearly demarcates, or one of the examples of hate speech that it clearly demarcates essentially is propaganda for war, which it makes illegal. So what about people who openly declare war on the Constitution? How can that not be hate speech and unlawful? Especially when people are campaigning for reductions in the Bill of Rights in order to target certain groups. How would that ever pass muster? How would that ever get past the Limitations Clause itself, which anything seeking to amend the Constitution would have to pass through the limitations clause, because it is the supreme law of the land. It does not get, just because you have the requisite votes in Parliament, does not mean you get to reduce the Constitution. You might be able to add things to it, but you cannot reduce it. You cannot negate things inside of it. That might seem an extraordinary view to some people, but let me just say that I'm a strict South African constitutional originalist in this sense. Parliament never promulgated the Constitution. The Constitutional Assembly promulgated the Constitution, and that does not exist anymore. The Constitution is not an act of Parliament. It will never be an act of Parliament. It is also an act of Parliament, but it is not an act of Parliament. It is the supreme law. And amendments that Parliament might wish to make are not above the supreme law. It's very simple. If you try to create a manifesto for a political party that seeks to undermine, subvert, or reduce the Constitution, that is unlawful. It is inconsistent with the supreme law. The people are also the fundamental author of the Constitution in a general philosophical sense. But that was also, in some sense, the presupposition, the moral presupposition through which the Constitution was authored. It's very interesting to see how, through the process that landed up with the amendment, the Expropriation Without Compensation Amendment, it's very interesting to see how that sought to obtain quite a contrived, ostensible democratic basis from the people in order to, by creating a false narrative and a false dilemma around why land reform has failed to materialize. All of this should have been circumvented by the courts if they were doing their job properly. This, in fact, was hate speech. And the normalization of fascistic hate speech continues to this day and is echoed by everyone because it is the new virtue signal of our fallen and corrupted society. Perhaps it is a function that our system was so good and so well structured that there was no room for corruption, that then the corruption had to go looking directly to corrupt the system that watches the watchers, as it were, or the fundamental tenet of this revolutionary constitution and revolutionary system of government and framework for law and justice. South Africa only works because of a common vision of justice. It was the only thing that could have bound our society. And when that was lost sight of, especially while it was being corrupted and toyed with, we lost democratic accountability. We lost democratic literacy. The electorate got drunk on the fascistic race baiting and scapegoating. And it quite disgustingly is going for the thing that stops even more corruption from happening. It's very interesting. The anatomy of a wicked and corrupt society. And I haven't actually, I've been remiss in this particular diatribe of not complaining about journalists, because it is certainly journalists that have heralded the fascistic academics and championed them in the framing of every debate that is always framed around the fascistic frame of reference and worldview, of providing sympathy to the immorality of groupthink and collectivization and systematization of blame in a society. That you can create systemic oppression and then find a representative of that systemic oppression and scapegoat a whole category of people, and that this is in fact what is called social justice. The irony, the Orwellian irony. It's a farce. It's a bread and circuses. And the journalists certainly have their role in the blame to go around in this institutionalized corruption. And they were the soft corruption first, and there are further details that I could go into, but they're very sort of historically peculiar, and in some sense they might sound conspiratorial to some people, but the treatment action campaign was funded by Chinese and Russian money, in my personal knowledge of some of these things, because South Africa was the primary tenant of it. It was the baton was passed on to us as it had passed from Britain to America, and finally South Africa was the center of the world, the moral center of the world. It was, and it still is, the iron rod that rules the nations. It is still ground zero and the central arena around which all other issues are the satellite thereto. It is the crispest, it is the most crisp and strident exemplar and illustration of the moral conundrum of really it all, at least in terms of how the human condition correlates to the issue of politics and government and justice. And my plan, my vision, my integrity is on the line in this. Well, I mean, that's to personalize the matter. One can also talk about. I mean, certainly I can't say that this is all about me. I mean, this is about everyone who lives in this territory that has a supreme law, that has been institutionally corrupted by a lot of childish malcontents in the, at least in the form of journalists, fascistic journalists that have been given free rein by judges that have normalized the liberal intolerance paradox and normalized fascism and created toxic political footballs for fascistic demagogues to make hay with. So I do have a special ire for journalists and for judges. again, on some level, perhaps this is more forgivable in the American experiment because this is all they have ever known. This is what the game has always been. They sit with another kind of, they sit with a culture war. South Africa doesn't sit with a culture war. The South African problem is not a culture war. The South African problem is institutionalized corruption. And if the world was perhaps had its head screwed on straight and was in a right mind, we would perhaps be living through a Nuremberg trial because we would have beseeched the international community to come in and remove our constitutional court for its fundamental betrayal and crime against humanity in the damage that they have done to the South African Constitution. The transgression of the liberal intolerance paradox, which our Constitution does make provision and fundamentally is capable of contending against. Anyway, I'm now getting into the point where I'm just repeating myself as I've already done so, but this has perhaps been a better recording that more clearly traverses all the topics.